was all over. Did you do all field tests goes through what you found in there? Or was it just hit and go? Not sure. I got you.
Yeah,
Okay.
yes, ma'am.
Mm-hmm. That's the one who took out the warrant, but you said they came at the last meeting. Yeah, no.
No comments?
Mhm.
Yeah, they were not there today. They had additional.
Wait, which one are you?
Yes.
Oh, yes. Warrants, gun. This is one taking the tree, but yeah, they took out the tree.
Deputy Gordon? All right, well, while we're waiting on him, good morning. I'm here, hopefully you're here for the motion to suppress involving the supposed roadblock. Your client is appearing virtually, not appearing. What's the plan?
She's the one that says iPhone right there.
All
You
right.
had trouble. Well, one of the things we'll talk about is the lack of transportation.
Okay, well, I see him now. He's right there. Okay, and we've got the courtroom. How do you pronounce your last name?
Senegar.
Say that again?
Senegar.
Sinegar. Good morning, Mr. Sinegar.
Good morning. How you doing, Judge?
I'm all right. We're going to get on the record in your case. Good morning, Ms. Rivers.
Good morning, Judge. How are you?
I'm doing well. Yourself?
Good. I'm good.
Great. This is 22 SC 185530, State versus Sinegar. Mr. Sinegar is appearing virtually. His lawyer, Mr. Majeski, is here in court, and we have Ms. Smith for the state. And as part of the regular flow, Mr. Majeski filed a motion to suppress. He alleges that there was a roadblock that is why Mr. Sinegar was stopped. The roadblock, according to Mr. Majeski, met none of the legal requirements for a valid roadblock. So he is seeking to have suppressed all the things that were found in Mr. Sinegar's auto, which I think was some drugs. I can't remember if there's a gun charge as well, but I'll pull up the indictment in a minute.
Sure, it was a gun. That's the co-defendant's problem.
Okay, all right. So you're not seeking to suppress the gun because it's not your client's?
Still seeking to suppress everything, just out of abundance of caution. However, I mean, I'm alleging there's an illegal seizure here, which would get rid of everything. I'm just saying, Mr. Sinegar's not charged with that.
Got it. Okay. All right. Ms. Smith, is there anything you want to cover procedurally before we dive into this, or are you ready to go?
I'm ready.
Okay. Well, if you want to call, well, gotta get old Deputy Gore. There he is. Two things. There is, in theory, a motions hearing in the Comer case on Wednesday, but there are no motions filed. He's not on this upcoming trial calendar. So there was nothing in the system for the 9th. But the day, if we were going to have a motions hearing, to have that was Wednesday. But if you could swear in our first witness, that would be great. And then you can let them know.
Your Honor, the state calls Michael Lynch to the stand.
All right.
Raise your right hand. Swear or affirm that testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You ain't got to see.
Good morning, Your
Please
Honor.
spell your name for the record.
Michael Lynch.
Before we get to your first witness, let me get one thing on the record. Mr. Sinagar, you are appearing virtually, which is okay. But I need to make sure you're waiving your right to be here in court. You understand you have a right to be here, but because of transportation issues or other reasons, you're appearing from wherever you are. You all right with that?
Yes, sir.
Okay. If at any point you need to speak privately with Mr. Majeski, let me know. And we'll get him to go into the jury room and log on to Zoom, and I'll put you guys in a breakout room. But you're going to be able to see and hear everything he can see and hear. All right?
Yes, sir.
Okay. All right. Sorry, Ms. Smith. Ready to go.
Thank you. Good morning, Mr. Lynch. How are you?
Good morning, ma'am. I'm Gary,
Good, good. What is your occupation?
Deputy Sheriff Lieutenant with the Fulton County Sheriff's Office.
And how long have you been with the Fulton County Sheriff's Office?
Going on 5 years now.
What was your occupation before the Sheriff's Office?
I work for the City of Fairburn Police Department as a sergeant on our traffic crime suppression / cops unit.
And how long did you work with the Fairburn Police Department?
2018 to 2022, somewhere there.
Okay. What did you do in your capacity as an officer when you were with the Fairburn Police Department?
We work traffic enforcement, everything from speeding, DUIs, hands-free, any like narcotics investigations, and any community stuff like, going to schools or community outreach programs.
Are you post-certified?
Yes, ma'am.
And were you post-certified on February 2nd, 2020?
Yes, ma'am.
During your time as an officer up until now as a lieutenant, have you ever conducted a roadblock?
Yes, ma'am. Several, probably over 100 or more.
As a law enforcement officer, have you ever received training in detecting motorists who may be under the influence of alcohol or drugs?
Yes, ma'am.
Could you tell us a little bit more about that training?
Yes, ma'am. I have what we call SFST, standardized filter body testing, where we run the subjects through a battery of evaluations from one leg stand, walk and turn, and horizontal gauge and nystagmus. I'm also a drugs unimpaired driving. I've had that certification. Also, ARIDE, which is Advanced Road Sign Impairment Driving Enforcement, which is where we can actually, it's actually another test for narcotics, stuff like that.
Okay. And did you receive this training prior to February 2nd, 2020?
Yes, ma'am.
In the course of conducting roadblocks, as you indicated you have in the past, have you ever encountered motorists who were under the influence of alcohol or
Yes, ma'am.
drugs? Okay. I want to turn your attention to February 2nd, 2020. I know this was a while ago, but do you remember working on that day?
Yes, ma'am.
Were you working in your capacity as a law enforcement officer on that
Yep.
day?
Yes, ma'am.
And were you participating in a roadblock?
Yes, ma'am.
Which outside agency were you working with to conduct this roadblock?
So it was with the Governor's Office of Highway Safety. Also, it's our traffic network, which is the Metro Atlanta Traffic Enforcement Network, which is comprised of 64 agencies. But the city of South Fulton was hosting what they call a Rolling Thunder. So it was South Fulton PD was the one that was actually hosting the event.
Okay.
Is the Governor's Office of Highway Safety, is that like a law enforcement agency? Are there officers of highway safety? I always think of like the state patrol.
No, sir, Your Honor. So they're actually a separate entity. They actually oversee like the traffic enforcement networks throughout the state. So they are post-certified officers.
Members of this Office of Highway Safety?
Yes, sir, Your Honor.
Okay. And they've got their own patrol cars?
Well, they're actually in unmarked cars, Your Honor. They actually oversee our traffic networks throughout the state. So I guess he would be the director is Alan Poole, who was a former state trooper.
Okay.
Now it's Cap Maurice Range, who's a former state trooper. Then they have people underneath them, what we call law enforcement liaisons that oversee the networks.
Okay.
Yes, sir, Your Honor.
But the roadblock that we're about to hear about from February 2, 2020 was a South Fulton PD roadblock.
Yes, sir, Your Honor. So what we did on that night is they bring in our heat units, which is highway enforcement aggressive traffic, which falls underneath the Governor's Office of Highway Safety.
Okay.
We talked a little about the Office of Highway Safety. Have you ever worked with them in the capacity of conducting a roadblock prior to this incident?
Yes, ma'am, for several years.
And on February 2nd, 2020, was anyone detained or arrested throughout the duration of that roadblock?
I think they made several arrests the entire night.
And are one of the people who were arrested during this roadblock, are they present either in the courtroom or on Zoom today?
Yes, ma'am.
Okay. Could you identify that person or that person who was arrested on February 2nd, 2020, and point out an article of clothing that they may be wearing?
Yes, ma'am. It's a gentleman in my left-hand corner right here wearing a white T-shirt with a white earbud in his left ear.
Your Honor, let the record reflect that the witness has identified Mr. Kevin Singar as the person or one of the people who were arrested on the night of February 2nd.
He has?
No objection.
Okay. I want to talk a little bit more about the defendant and their arrest a bit later, but first I want to talk a little bit more about the roadblock. Where was the roadblock set up on this day?
The last one when we encountered the defendant was on Old National Highway.
And was there any particular reason that you all set up the roadblock at that intersection?
From what I was told by South Fulton, we had a lot of fatalities out on Old National Highway and a lot of DUIs.
And before conducting a roadblock, is there some type of procedure or standard procedure that the agencies have to follow to set it up?
Yes, ma'am.
To your knowledge, who organized the roadblock that was set up on February 2nd, 2020?
That would have been South Fulton Lieutenant Roxy Shoemaker, who was over the traffic unit.
And as the lieutenant, would you say she was in a supervisory personnel position?
Yes, ma'am.
And I want to kind of get a feel of how the scene was set up. Was the roadblock well identified?
Yes, ma'am. So they actually had the orange cones. We knocked it down to one lane. There was marked patrol units with blue lights as well. Officers were out in the roadway area wearing reflective vests.
Okay. And during this roadblock, were all of the vehicles stopped as they approached the checkpoint, or were some vehicles able to leave and divert from that route?
So as long as we were conducting the road check, we stopped every vehicle, but if traffic got backed up, we run every car. After the last one we checked, we started running cars through until there was no more traffic, then we started over again.
I want to make sure I understand what you just described. So if it's light traffic, every car that comes up to the checkpoint, you do whatever you do. Same thing for everyone. But if then there's a long line of cars, traffic is building up. At some point, you decide to say, not you, someone decides, let everyone through until traffic thins?
Yes, sir, Your Honor. That would have been Lieutenant Shoemaker.
Okay. That's the South Fulton lieutenant.
Yes, sir, Your Honor.
Okay. And you said the way the roadblock worked is that with cones, it narrowed Old National down to one lane?
Yes, sir.
Okay. And is that in both directions?
No, sir, we only checked the, I'm not for sure which way it goes, but going toward 138, back toward Clayton County.
Okay. So let's pretend that's northbound. Southbound traffic is flowing as it would, but northbound or whatever direction
Yes,
it is,
sir.
that's the one that was narrowed down to one lane. And you couldn't just drive through at the speed limit. You actually, if there wasn't a lot of traffic, if I'm in that one lane, I had to stop and have the interaction with law enforcement. And that was the case for every car until or unless traffic built up.
Yes, sir, Your Honor.
Okay.
So on February 2nd, 2020, was the defendant one of the drivers who came through the roadblock?
Yes, ma'am.
Was the defendant detained at any point?
Eventually, after he was taken out of his vehicle, he was detained by, I think it was South Fulton Corporal Goodman.
Okay, and why was that?
He was placed under arrest for possible impairment.
After the defendant was arrested, was there a search of the vehicle he was driving?
Yes, ma'am.
And what kind of car was the defendant driving?
I don't remember the color, but I know it was a Dodge Charger with Mississippi tags.
And is this a search that you conducted?
Yes, ma'am.
What items did you recover as a result of the search of the vehicle?
Underneath the front passenger seat, I located a handgun. Also, when I went around to the driver's side, underneath the driver's seat, there was like a camouflage bag, probably about like this, that contained some narcotics. Once I located narcotics in it, I left it there and let Corporal Goodman know.
Okay. Earlier, you mentioned the intersection that this roadblock was set up. I forgot to ask you, what county was this roadblock set up in?
In county.
After you conducted the search of the car, where was the defendant taken?
He was taken to the South Fulton precinct, but I think on Old National.
Thank you. No further questions.
Before Mr. Majeski goes, so the car was stopped because cars were being stopped there, and then someone had an interaction with Mr. Sinigar, who was the driver, and determined that he was impaired.
Yes, sir, Your Honor.
That wasn't you.
No, sir, that was Officer Goodman with South Fulton.
Your role in connection with what we're talking about was to search the car.
Yes, sir.
Okay, were you the only one who searched the car, or did you have, like, you found both the gun and the camo bag?
Yes, sir, Your Honor. So once I found the gun, we secured the gun. Once I found the bag underneath the front passenger seat, I left it right there for Corporal Goodman.
Okay. Officer Goodman, Corporal Goodman, that's the same person?
Yes, sir, it is.
Okay.
I apologize, Your Honor.
That's okay. And that's the person who had that interaction with Mr. Sinigar and determined it's not safe for you to drive, you got to get out of the car.
Yes, sir, Your Honor.
And was he, Mr. Sinigar, under arrest and that's why you searched the car, or because it was a roadblock, or what made you think it was okay to be in his, I don't know if it's his car, but in that Charger?
Yes, sir, Your Honor. So Corporal Goodman actually placed him under arrest.
Okay.
And we searched the vehicle incident to arrest.
Got it. Was there another passenger in the car?
Yes, sir, Your Honor.
Okay. And did he say, well, wait, I'll drive the car away, or anything like that?
So, Your Honor, he wasn't, when we checked him, his license was suspended, so he couldn't actually take the car.
Got it. So there was no one there in the car to say, I'll drive the car away?
No, sir, Your Honor.
All right. Did I ask anything that makes you want to follow up on any of that?
No, Your Honor.
Okay. Mr. Majeski.
Good morning, Lieutenant.
Good morning, counsel.
How are you, sir?
I'm great. And yourself, sir?
Not bad. Listen, question for you.
Yes, sir.
After Mr. Sinigar was taken out of the car, the passenger was left in the car during the field sobriety evaluations, was he not?
Yes, sir.
And he was not taken out of the car until after the field sobriety evaluations were concluded. Am I right about that?
Yes, sir.
And you were there, you saw that whole thing?
Yes, sir. I was standing by with the passenger.
Okay. Field sobriety evaluations, it takes a minute to conduct those, right?
Yes, sir.
Because that's the HGN,
Yes, sir. That's one of them.
the one leg stand,
Walk and turn, then one leg stand.
and plus you got to medically qualify them.
What do you mean by that?
Medically, well, do you have to medically qualify an individual before administering field sobriety tests according to your training?
We don't medically qualify. We ask them if there's any thing that will prevent them from doing a walk and turn or one leg stand, or if they have any problems with their eyes.
Sure, like head injuries or things like that, right?
Okay. I thought, like, if his head was split open and there's blood everywhere, no one's going to administer a field
No,
sobriety
no,
test.
sir, Your Honor.
Okay.
Or if they,
I'm sorry, I didn't mean to interrupt you.
no, sir, or if they had like a head injury, prior head injury, stuff like that.
Sure, that's just because it could affect the validated clues you're looking for.
Yes, sir.
And that's according to NHTSA, right?
Yes, sir.
Point being, all that takes a little bit of time, right?
Yes, sir.
And you also like to ask a few questions about where you're coming from, where have you been this evening, to give potential other indicators of intoxication. Am I right about that?
Yes, sir.
And that also takes a couple of minutes, correct?
Yes, sir.
Have you reviewed the incident reports that were completed with respect to this
Yes, sir.
arrest? Okay. Judge, can I approach the witness?
You may.
Could you take a look at that for me?
Yes, sir.
Just let me know when you're done, please.
This is the report that was provided to me.
Thank you. You familiar with that?
Yes, sir.
Copy of that?
Yes, sir.
You agree with this report?
Yes, sir.
Okay. On page 6 of the report, right here,
Yes, sir.
would you agree with me that it says that the purpose of this particular roadblock was to show law enforcement presence, curb drivers' behavior, and arrest traffic law violators?
Yeah, if that's what their road check was set up for, I didn't have privilege to actually be a part of the, I guess the setup, actually, what they were going to look for, stuff like that.
And we call that at the programmatic level. You were not involved in setting up and organizing this roadblock at the programmatic level,
Right,
correct?
yes, sir.
You were just kind of there because you're a highly trained officer and you're useful to detect impaired drivers.
Right, so we're part of what we call the Metro Atlanta Traffic Enforcement Network,
Okay.
which is governed by the Governor's Office of Highway Safety.
Who would it have been a South Fulton police meeting where they got together to say, here's where we'll do it and the time and here's why? Or would it have been this Governor's Office of Highway Safety?
So they would reach out to the Governor's Office of Highway Safety, say, hey, we want to do a road safety check. This is what we're looking for, stuff like that. Then the Governor's Office of Highway Safety will require what we call our heat units in any agencies within our network to show up to be screeners, spotters, and South Fulton would handle any arrest, any DUI, stuff like that.
Got it. But I think I follow that. But it sounds like what would happen first is that a member agency of the Highway Safety Board, and it sounds like this time it was South Fulton.
Yes, sir.
They said, hey, we need to do a safety check, roadblock, call it what you will, checkpoint. We need to do it at this intersection on Old National Highway for fill in the blanks, the reason. And there's something in the report that says whatever Mr. Majeski said. That decision-making and articulation of the reason for, necessity for the roadblock, that all came from South Fulton. That wouldn't have been also Fairburn or the Office of Highway Safety.
Correct, Your Honor.
And then that agency, this time South Fulton, says, great, we've got a reason to do it and a plan to do it. We'll reach out to the Office of Highway Safety, and they then tickle that network. And that's why you were there, and there may have been an officer from East Point, and there could have been state trooper, people who are part of that Office of Highway Safety.
Yes, sir, Your Honor.
Okay.
Once again, you weren't part of any of those discussions. The judge just a tribe, were you?
That's right, counsel.
All right. You weren't told the duration of this roadblock was supposed to last for?
No, I know they said it'd probably go to about 4 or 5 in the morning.
All right. And during this time, not every car was stopped because you let some through due to traffic, right?
Once traffic started getting backed up, Lieutenant Shoemaker would make the decision to let traffic flow to clear out traffic.
And that was completely, I guess, arbitrary or determined by this lieutenant, correct?
Yes, sir.
So while the roadblock was operating, it either started or stopped, or not every car was stopped, correct?
Yes, sir.
All right. Thank you, Judge. No further questions on this witness.
And redirect?
Yes. Lieutenant Lynch,
Yes,
the
ma'am.
report that was shown to you by counsel, was that a report that you wrote?
No, ma'am.
Okay. What was your understanding of the purpose for the roadblock?
To find impaired drivers.
And is it usual for agencies to collaborate together to conduct these roadblocks?
Yes, ma'am.
And and in this case, you all work with South Fulton?
Yes, ma'am.
And have you worked with South Fulton in the past to conduct roadblocks?
Yes, ma'am.
And you're familiar with the process of how roadblocks are conducted?
Yes, ma'am.
And throughout your experience of conducting roadblocks, is the process or how it was ran, is it similar to the way that the roadblock was conducted in this case?
Yes, ma'am.
Thank you. No further questions, Your Honor.
All right.
Couple more questions, Judge?
Sure.
Thanks on that. Lieutenant, show me page 6 again.
Yes, sir.
That report was written by a South Fulton police officer, correct?
Looks like Investigator Reed.
Okay, and there's a supervisor listed there. Is that the lieutenant you're talking about?
No, sir. The supervisor here is, I think that was Lieutenant McKessie.
Sure. And who did you say authorized this whole thing?
That would have been Lieutenant Roxy Shoemaker. I think these two here, counsel, are on the drug task force. She was the lieutenant. I don't know if he was an officer or a corporal.
Sure. Now, one of the officers, you agree with me, this is written by a South Fulton police officer, correct?
Has his name on it. I'm presuming he wrote it.
Big problem if it wasn't, if it's a report.
Yes, sir.
And this does say the purpose for that roadblock was law enforcement present, curb driver's behavior, and arrest local traffic violators, regardless of what they told you, correct?
Yes, sir. That's what it says in the report.
All right, thank you. No further questions, Judge.
Can you read that phrase again?
Sure, Judge. What it says here, and actually, Judge, for the record, because we can use hearsay at the preliminary stage to determine the admissibility of evidence, I'd like to introduce this as an evidence of defendant's exhibit 1.
Okay, and that's the South Fulton Police report relating to Mr. Sinigar's arrest.
It's actually several police, with a couple different police reports, it's South Fulton Police Report. For completeness and fairness and everything, we'll just go ahead and introduce the whole thing. What I'm specifically talking about is page 6.
Right, but is that a singular document, or is that a compilation of documents?
I don't know.
Well, the pages are numbered. Did you number the pages, or does the report number the pages?
Report number the page.
Okay, so if it's 1 through 6, it's a 6-page report.
Sure, it was given to me as a singular report.
Okay, all right, and it's from South Fulton.
Yes, Judge.
Okay,
So to answer the court's question, it says right here, page 6, second sentence, second line, halfway through. I'll just start at the first. The City of South Fulton Traffic Unit, along with the Governor's Office of Highway Safety, were conducting Operation Thunder Task Force on Old National. The purpose is to show law enforcement presence, curb drivers' behavior, and arrest traffic law violators.
all right. Ms. Smith, any objection to making defense 1 part of the record for the suppression hearing?
No objection, Your Honor. However, we would just like to make note that the scope of this motion is to determine if there was a roadblock and if the roadblock was valid. However, I do know during questioning, we got a little bit into the sobriety test, but as far as the report, the state would just argue that the only relevant parts would be about the roadblock and how they were conducted.
Okay, I will admit defense 1 and take that from you.
Thank you, Judge.
All right. Anything else for the lieutenant?
Can I promise?
Yes.
Thank you. No further questions for me for the lieutenant.
Okay.
Thank you, Lieutenant.
Yes, sir, counsel.
Tell me what you do for the sheriff's office now.
So I was actually brought over, the sheriff recruited me to start the first ever traffic unit for the sheriff's office, but since then, the jail shoring.
Yeah.
Yes, sir, Your Honor. So I do jail security now. So I handle everything coming all the way into the doors, everything around the jail, all the checkpoints and stuff like that.
Little bait and switch, huh? Oh, well.
Yes, sir, Your Honor.
Well, we're glad to have you with us.
Yes, sir, Your Honor.
Thanks for your time.
Yes, sir, Your Honor. Okay, to be dismissed.
Yes, sir. Ms. Smith, anything else?
Nothing further from the state, Your Honor.
All right, Mr. Majeski, any evidence you want to put on?
No evidence of defense, Jay.
All right, then let's turn to argument. As the movement, tell me why you think, whoops, hold on one second. All right, why you think this should be suppressed?
Sure, Judge. A little bit of background as far as roadblocks go here. Kind of taking a little bit of circuitous turn under Georgia law. Back in the 90s, we had LaFontaine that was later modified by McCoy. And I've got a particularly useful case, rather robust discussion by former Chief Justice Damius, who was prone to do this sort of thing. That's going to be Williams versus the state, 293 Georgia, 883, 2013. Now, when we're dealing with roadblocks, Judge, we only use a 4-part test in Georgia now. That was determined in McCoy. So not even going to talk about the screening officer's ability to make this impairment. According to McCoy, as long as you're post-certified, we're talking about reasonable suspicion, good enough. So throw that right out the window. However, the 4 things that we're explaining now, are talking about now is there's got to be a purpose for the stop other than Georgia regular law enforcement concerns.
You say purpose for the stop, purpose for the roadblock?
Purpose for the roadblock.
Okay.
Every car's got to be stopped. The delay to the people has to be minimal. And the place has to be marked as a roadblock for people who decided this. Now, when we get into the first praise, Williams tells us that we got to ask a couple of questions. Was the police checkpoint issued and implemented pursuant to a checkpoint program that had, when viewed at the programmatic level, an appropriate primary purpose other than general crime control? That's the first thing NAMI says that we got to talk about, citing other cases. Problem here is I don't have to prove this roadblock was illegal. The state has to prove that it was. I met my burden by saying it was illegal in every respect in my pleading. What we don't have here is evidence that this thing was constituted at any kind of programmatic level. And here's why. I don't hear anything about South Fulton, nor could we have, because this deputy never worked for South Fulton, as far as their policy for roadblocks. Nor did I hear anything about Heat's program for instituting roadblocks. If so, was the decision to implement that specific checkpoint made by a supervisor in advance rather than by an officer in the field? I don't know. You can read that entire police report and you can remember the testimony, and there's no evidence about that whatsoever, about when this decision was made to implement it, what role the supervisory officer supposedly had in it, or anything else of that matter. And the bigger problem, Judge, is, and I did not realize this until the officer is testifying, because the reason I filed this motion to suppress is because there's precious little about the validity of the roadblock in the police reports. Judge, not every car was stopped. See, the purpose, as Namias points out in McCoy, for stopping every car and having all these constituted roadblocks and everything is we cannot let law enforcement have an end run around stopping vehicles that they had no reasonable articulable suspicion to stop absent the roadblock. That's the whole point of Edmonds, even going back to the Supreme Court's decision. We're talking now about we stopped some cars until traffic got too heavy, and then everybody else got to go through, and then we resumed stopping cars. Well, like I asked the officer, that's either starting and stopping this roadblock numerous times, we don't know how many, during this roadblock, or the roadblock was continuous and we violated Edmonds and McCoy by not stopping every car. Either way, I win. Because not every car was stopped. That is a requirement even from Edmonds. No matter how trivial it might sound, that is the most important part of Edmonds, is to making sure it's not used for harassment. Who's to say that my client, had he left 2 or 3 minutes later, might have been determined to be in too much traffic, just slid through the roadblock? It's an arbitrary determination by the law enforcement officer. And it cannot be allowed to stand on that part. And given the fact that, number one, that occurred. Number two, we don't know anything about the programmatic level here. And number three, if you read the police report that they actually wrote, there was an improper reason for instituting this roadblock to start with. Show police presence? You need a roadblock to do that, Judge. That's why we got markings on the side of cars. That's why we got police cars that hang out of various different high crime places. It happens all the time. Curve drivers' behavior? That sounds like general law enforcement. Punish traffic law violators? That's general law enforcement. This whole thing was set up for general law enforcement coming from a club in a high crime area, and that's pretty much it. So, Judge, I mean, pick a reason. This roadblock was improperly constituted, improperly conducted on every level, and I mean, I just don't see a way around suppressing this evidence, Judge, based on the fact that my client was illegally seized.
Are you familiar with any case law that addresses the tension between the second part of the 4-part test and the third? The second part is every car needs to be stopped. So you avoid your concern, which is, you know what, we're going to let every third car through, or every nice car through, or every car driven by a tall person. And number three, which is try to minimize the delay, which would be, you know, we'll have a roadblock, but now traffic is backed up 15 minutes. So we're going to stop the roadblock and everyone can go through. We're not going to say, well, but that car looks a little suspicious. We take away the roadblock, if you will. I don't think they moved anything. They just let traffic flow in that one lane. And when there was no more traffic, they turned the roadblock back on.
I'm not, Judge, but taking that to its intellectual conclusion, allowing that sort of thing in the context of these highly regulated roadblocks would quite frankly make Edmonds, McCoy, and everything else like that useless, because what constitutes unnecessary delay in traffic? 5 minutes, 10 minutes, 15 minutes?
Sure, it's a rule of reason, and they would evaluate it each case as it comes.
But now we're giving that discretion right back to law enforcement, who we're supposed to be taking it from. It's different than a reasonable suspicion case or a probable cause case where we look at the totality of the circumstances. It's a bright line rule that these things have to happen. So I don't see any tension between those two things. I see them as absolute imperatives that happen to be right next to each other on the list.
Okay, got it. Thank you.
Thank you, Judge. And I guess I'll reserve for any rebuttal that I may have.
Ms. Smith, your thoughts?
Yes, Your Honor, thank you. Your Honor, the state respectfully requests that the court deny the defendant's motion to suppress. The defense contends that the roadblock conducted on February 2nd, 2020, that resulted in the defendant's arrest was unlawful, and as a result, they assert that all evidence obtained from that stop must be suppressed. However, the evidence that the state has provided shows that the roadblock was lawful and was valid. As mentioned previously, I would like to bring the court's attention to McCoy v. State. The citation is 303 Georgia 551. This is a Georgia Supreme Court case that was decided back in 2018, where the court held that there were around 4 to 5 factors that the court had to take into consideration to determine if a roadblock was valid. Before I get into those 4 or 5 factors, Your Honor, these factors are not determinate. All of them do not have to be met. It's not a bright line rule. It's just 5 different requirements or 5 different factors that the court looks at to decide if a traffic or a roadblock was invalid. In this case, Your Honor, starting with the first requirement or the first prong, that the decision to implement the roadblock was made by supervisory personnel rather than the officers in the field. We heard testimony from Lieutenant Lynch today, who partnered with South Fulton and also the governor's office to conduct this roadblock. He stated that Roxy Shoemaker, the lieutenant at the time, was the one who conducted this roadblock. And the incident report was not the only piece of evidence that we heard today. As stated, we did hear from Lieutenant Lynch, who was nevertheless at the scene and did have information regarding the roadblock, such as who was the one who set it up. And in this case, the test does not require that the supervisor is the one to come and testify, that the supervisor is the one to give documentation to everybody working on the team during the roadblock to let them know I was the one that made the decisions. However, the element here just says that the roadblock has to be implemented by supervisory personnel rather than an officer in the field. Lieutenant Lynch told us today that that person was Roxy Shoemaker in this case. The second prong of the McCord test is that all vehicles are stopped as opposed to random vehicle stops. We heard from Lieutenant Lynch today that during this process of the roadblock, if traffic was light, they were stopping all of the vehicles. It was a decision by the person of authority, who was Ms. Shoemaker, to then divert or let traffic go through if traffic began to be backed up. There's no evidence or no case law presented today that shows that if every car is not stopped, then to the contrary, the roadblock is then invalid and every person that comes through their Fourth Amendment right has been violated. However, what the state did show today is that the cars were not stopped at random. They were not stopped based on the type of tires they had, the type of car it was, or the type of person that was driving it. Every car that came through that roadblock when traffic was light, because the importance of this roadblock is to not only determine who may have been driving impaired, but also the safety of the roads. So to make sure that the roads were not as backed up with a lot of traffic, when traffic was light, the officers did make sure they stopped every vehicle. That third element that we have in this case is that the delay to the motorist is minimum. We heard from, again, Lieutenant Lynch, who told us that when they stopped these cars, based on the observations, it goes from there. So if a person came through and they did not smell any alcohol, if there was nothing suspicious about what was going on, the motorist was free to leave and they kept going. However, as it shows, if you're stopped and the officers smell not marijuana, if they smell alcohol or it gives them probable cause to search a car, well, that stop is more than likely going to take longer than the stop of a motorist who had no smells coming from their car. In this case, the defendant was taken out of the car when the officer smelled the alcohol. His passenger was taken out of the car and the car was searched. The search of this car was not delayed. It was not prolonged based on, again, who the defendant was or the roadblock in general. It just happened to take longer because it was two defendants in the car. It was also a search that the officers wanted to do because they smelled that alcohol. And also with the fourth element in this McCoy test, the roadblock operation is well identified as the police checkpoint. We heard today that the officers had cones, they had on vests, they had police cars there. It was very obvious that there was a roadblock. The officers were not trying to hide anything. As we heard, the roadblocks in this area are frequent, are not uncommon, because they want to make sure that this area is going to continue to be safe. That's why they set up the roadblocks initially. And also that fifth element here, the screening officer's training and experience is sufficient to qualify him to make the initial determination as to what motorists to detain for field sobriety tests. Now, in this case, I do know McCoy in the Supreme Court stated that they don't weigh heavily on this factor.
Can you say number 5 again? I was making a note on a different page.
Yes, the fifth element is that the screening officer's training and experience is sufficient to qualify him to make an initial determination as to which motorist they should pull over to determine if they should do field sobriety tests or not. And as we heard in this case, although Lieutenant Lynch was not the officer who took the defendant out of the car and did the screening for the sobriety test, nevertheless, he did receive the training to be able to determine if a person is under the influence. And also here in the McCoy case, the Supreme Court emphasized that they don't weigh heavily on this element as if an officer is post-certified, that it's not something that the court relies the most on is really the first four elements. And also just to reiterate, those first four elements they're not determinate. It's not like if one doesn't exist, the entire test falls apart. However, these are just weighing factors that the court look at in order to determine if the roadblock is valid. Looking at this case, the state would still argue that the roadblock was sufficient. The roadblock was valid. It was made by a person who was the lieutenant at the time of the South Fulton Police Department, who has since retired. Looking at the four corners of this motion we have here, it's not about if the field sobriety test was valid, if he was supposed to be taken out of the car. The problem that the defense has highlighted here is if the roadblock was valid, if the roadblock was legal. And that's what it was in this case, as it meets the first four elements of the McCoy case, in the McCoy test in this case. In conclusion, Your Honor, we would just ask you to deny the motions from the defendant to suppress the evidence found as the roadblock, as the state contends, was valid in this case. Thank you.
So you're welcome. You don't think the fact that it was I'm gonna call it an intermittent roadblock, is fatal here? It was a roadblock until traffic built up too much, and then it sounds like Lieutenant Shoemaker would say, all right, step back, let's let some traffic through. All right, I don't see any cars backed up. Now let's flip it back on. You don't think that's runs afoul of that requirement of every car being stopped?
No, Your Honor, because for a certain period of time, the lieutenant made the decision to let a certain amount of cars go. Not, we're going to stop at the green car, we're going to stop at the blue car. It was just until traffic lets up. It wasn't during a specific time, we're just going to let certain cars through.
Okay, and it wasn't, we'll just let certain cars I say can go through. It was everyone can go through until traffic thins out, and then we stop every car.
That's correct. So for instance, hypothetically, if she says for the next 30 minutes, we're going to let every car go through until traffic slows up, or during that 30 minutes, they're not saying, hey, let's stop this car because it looks suspicious. Every single car was allowed to go through. And then once the traffic lightened up, every car that came through was then approached by an officer based on that roadblock.
Okay, thank you.
No problem.
Appreciate it. Mr. Majeski, final word, if there's anything you want to add.
Thank you, Judge. Respectfully, I disagree with my dear colleague that all four of these things don't have to be met to to make a valid roadblock. I'm giving you Williams, she's giving you McCoy.
McCoy's newer.
Well, McCoy modified LaFontaine, but does not have any effect on Williams whatsoever. What I'm telling you about here, McCoy won in that case because LaFontaine, as Georgia courts sometimes do, because we're allowed to provide more constitutional protection, introduced a fifth element to the Edmund test.
And that's the qualified screeners.
Sure. McCoy probably rightly said, it doesn't matter. What we're dealing with here is the actual stop at the roadblock, and that actual thing kind of occurs after the stop, so it doesn't really add anything to the Edmonds.
Right. If the roadblock was no good, it doesn't matter how qualified the screeners are.
Right. But I think even McCoy, and I got it right here, it's newer, reaffirms that there are, in this case, 5 when they're talking about it. Of course, they later got rid of the 5th one, but it says right here, the decision to implement the roadblock was made by supervisory personnel rather than officers in the field. All vehicles stopped as opposed to random vehicle stops. The delay of the motorist was minimal, and the roadblock operation was well identified as a police checkpoint. You got to have those 4 things. You always have, ever since Edmund. And in this case, based on the facts that we have here, and when you go, and I know the court's going to read these cases if you haven't already.
A long time ago, I haven't had a roadblock challenge in several years, so I've got my old order, and I'm sure it cites McCoy and Williams, and I'll go look at them.
Right, and this is a court that thinks. Before this, I've got several orders in this other case. However, what you're going to do is when you go back and you read this, and you're going to read about the programmatic level and everything like that this has to be decided on, you're going to realize there's no evidence of that in this case, either from Heat or from South Fulton or even Fairburn. And once again, I'm not accusing this officer of any wrongdoing. I'm just saying that whoever put him in this position either didn't document this well enough or hadn't read these cases. But you're going to find no evidence that this is made at a programmatic level. You're going to find no evidence of when this was decided to be constituted, as opposed to before, or we're just going to do it now. And you just can't have intermittent roadblocks. If you have intermittent roadblocks, it's not a roadblock. It's just a police-induced pain to search random cars, which is specifically the evil that Edmonds seeks to militate against. So, Judge, I just think based on that, it's kind of an easy call. It was a bad roadblock.
All right.
Thank you, Judge.
You're welcome. Mr. Sinigar, are you still there? I see iPhone, but there's no camera.
Yes, sir. Yes, Your Honor.
Okay. Were you able to hear everything we were doing?
Yes, Judge.
Okay. All right. Do you have any questions about anything we discussed?
No, sir.
Okay. All right. Well, I will take this under advisement and get an order out. Let me see. Okay. All right, so final plea isn't for a few weeks, so I'll get the order out before final plea, and we'll take it from there.
Sure. There's one other issue, Judge.
Yes?
Filed two motions in this case. I don't think the state has much of an opinion.
Oh, the motion to return property?
All right, Judge. So this has a long and tortured history. I think I got this case. I took this over for Mr. Joshi in like 2004.
Wow.
I filed a motion to return the property because they took his car as evidence. I don't know why you take a car as evidence in a DUI or a drug case. I've never seen it done before. I could maybe, but then we had this big thing about, are we trying to forfeit the car? Are we not trying to forfeit the car? So on and so forth. The amount of drugs here would have given rise to a forfeiture, but nobody tried. So the car sat in evidence from 2020 is when this case happened. Middle of May 2004, Judge Frazier gave me an order to give the man his car back because I talked to the DA at that point. Why are we holding this car? It's got no evidentiary value, and it's been 4 years. Got that order, gave it to Mr. Sinigar. He goes down to the towing people. They're like, great, give us 40 grand. Wasn't his fault they had the car. It's not like he had an expired tag, and therefore the car had to be impounded. They said they needed an order from a judge saying, they got to release it without being paid. I went round and round with various non-complex judges, prosecutors. They're all basically like, yeah, we'll sign it for you. Well, actually, now that we thought about it, we don't really have that authority. And the point is, Judge, this towing yard's had his car for 6 years, even if it's still in business. Through no fault of his own. So I just like you to sign an order saying, give him his car back and don't charge him for it. It's not his fault. Y'all had it.
I don't see the order in the docket. There are a bunch of scheduling orders. For whatever reason, this case bounced around a lot, but I don't see anything from a judge saying hand over the car. Let me go to the next.
All price. Do you mind if I take a look here in my files, Judge?
I don't mind if you look.
If you recall, this case came to you. I mean, it was one of the things that made it kind of messy was they indicted it twice for some reason.
Oh,
And then we kept going back and forth on which indictment are we going to travel under. And then it got to your division and you made that decision for us.
oh yeah. Let me look up this other case. Yes, May of 2024, consent order for the return of property, consented to by a former colleague of Ms. Smith's, and you wrote it, and it's just about the, automobile and chains. Did he get his chains?
That's a whole other sore subject, Judge. That's one of the reasons. There is no video in this case, and I wanted to use the video no, he did not get his chains because they're saying they don't have the chains.
Okay.
Not a whole lot I can do about that, but the car, he's clearly entitled to get that back.
Got it. Ms. Smith, ADA Averill Jackson consented to the return of the car back in May of 2024. Any reason you wouldn't consent to it again, if we try again to get the car back to Mr. Sinegar?
So the state consents, Your Honor, and I reached out to the South Fulton Police Department about
Oh.
this request, and they said that if they received an order, they would release the car. However, there's still a payment that is due to like the towing company that's out of their control because they just released the car.
Got it.
That's an update that I got from the South Fulton Police Department.
Okay. Well, thank you. Mr. Majeski, I'm going to put the pen back in your hand, and why don't you draft up a consent order? You're going to probably want to figure out who the towing company is or whatever, so I can be clear in there that company X is to charge Mr. Sinegar $0, and they're commanded to release it, and run the order by Ms. Smith, make sure she's okay with it, and get it to me. I'm happy to sign that. I can list these chains again as well, meaning the jewelry. I don't know that's going to help, but the state didn't oppose it then. They're not opposing it now. It just sounds like you'll want to put in the order something express directed at whatever the towing company is that's holding this Charger that probably has 4 flat tires by now.
Sure, Judge. Yes, I'll get that over to Senator Ms. Nelson after I clear.
Yes, please.
Thank you, Judge.
All right, so my homework is I'll look for that and send it in Word format. That's the easy one, but I will also get to work on ruling on the motion to suppress the fruits of the roadblock. Anything else from the defense?
Okay.
All right, anything else? Ms. Smith?
Nothing further, Your Honor. Thank
All
you.
right, thank you again, Lieutenant. Back to jail.
Mr. Judge, one thing. So I just had one question. So about the chains. So what? I won't be able to get those back.
Give me a call. I'm gonna explain what the judge just said. We're still worried about that. Just give me a call about that.
All right.
But so you can hear it from me, I'm not opposed to getting them to you. What I heard Mr. Majeski say is that South Fulton Police has said, we don't have them. And if they don't have them, I don't know who else to tell to give them to you. But that shouldn't be news to you. This was a couple years ago.
No, exactly. Yeah.
Okay, so no, the order will say release to you both the car and the jewelry. It sounds like everyone knows where the car is. The jewelry is the mystery, but can try again.
Yep.
All right.
Thank you.
All right. You're free to go, Mr. Sinegar.
Thank you. You have a good day, Judge.
You too.
Thank you, Judge. That concludes our business with you this morning. Can I be excused?
Yes, sir.
Thank you.
All right. Before we turn to our probation revocation, Ms. Gladden, good morning.
Good morning, Your Honor.
Judge Emerson said that Mr. Perry wants to resolve his case.
Your Honor, I need to speak to Ms. Smith again, but after our conversations yesterday, it appears as if we have finally possibly reached a resolution. There are issues with Ms. Taylor. I don't know how necessary.
But she represents Ms. Hightower.
Right, I don't know if the court has any feelings about that, but yes, I need to finalize it and with Ms. Smith to see if it wasn't a definite offer yesterday. She said, maybe I would think about this, so I need to discuss that with her, but if the court would take it or the court wants Judge Langford to take it, assuming all else is the way I think it is, we would be ready to enter a plea.
Okay. Mr. Perry Haler, have you been deputized to work out his other one, or this would just be working out the home invasion case?
The home invasion, Judge.
Okay, I'll take that. That's better than nothing.
Absolutely.
So Ms. Smith is popular this morning. We just finished a suppression motion. We're about to get to a probation revocation hearing. Judge Emerson has said he is happy to take the plea, but we need a prosecutor to do that.
And of course, the judge knows that this involves, the charges are serious.
They are.
And, with our resolution, assuming, depending on Ms. Smith, I believe there would need to be an explanation put on the record, but, I'm at the court's discretion, depending on what your honor decides. I am supposed to be in Cherokee County. I filed a conflict letter, but I did want to let them know
Yep.
whether I will be able to, it's just for a plea there, Judge, but it was a last minute thing because I did not think we were gonna be added to today's calendar, so I don't like to file a conflict letter if it's not a conflict at the time.
Right.
I should have, especially when it may be resolved and I can make it. So I just need to, speak to Ms. Smith, as she's speaking at the court, thinks it's gonna take long, and that's a plea in misdemeanor court there. It would be nice to let the court know that I may not be available, because it might be a while before we could take the plea on Mr. Perry. So I need to speak to Ms. Smith to finalize potentially the plea deal, and then to let, Cherokee County know, an idea if it's a part of Judge Langford, that's fine, Your Honor, but a prosecutor's gonna have to know a little bit more about the case. I don't know how a plea would go down without them knowing the defense's side, because that's very involved in the plea offer that we finally have.
Got it. Okay. I think I follow all that. Let me write something.
I haven't plea offer yet, but in the potential plea offer, the defense's evidence is very significant, is a big part of the plea offer at this point. And, I don't know, I hate to put that on another prosecutor, but I mean, I'm fine, Judge. I can explain why I think that it's gonna resolve the way it is. I'm just at the court's discretion, Judge.
Okay. Give me a second.
Sure. And I also want to thank Ms. Smith for giving me the time she's given, for listening to me for probably an hour yesterday, discussing this case, Judge, and getting on it at the last minute and being so responsive. And the court's indulgence and all the things that have been going on since we've been trying to get this case resolved, Judge.
Yep, it's been quite a case. All right. Let me first. Mr. Rakestraw, Deputy Gordon, he's here. He's up. You don't have to get him yet. I'm just figuring out what we're doing. Ms. Smith, you're ready to go on the Rakestraw revocation?
I am.
That's why we have the officer here?
Yes.
Okay. Counselor, are you ready to go with Rakestraw?
I was wondering if I could speak with the state prior to.
Sure. She's popular. Ms. Smith, if you would speak with Mr. Rakestraw's attorney for a sec, just to figure out if that's going forward. And then, Ms. Gladden, you should let Cherokee know that they may see you this afternoon, but we need to sort out if we can do the plea this morning. If Judge Emerson has to press forward, if one of the cases ahead of yours is actually ready, I'm going to have him do that, and we'll take Mr. Perry's plea. Is he sitting down in 1D right now? Okay. All right. So you should sit tight. We're going to figure out what we're doing with Mr. Rakestraw's revocation, and then we'll also figure out what we're doing with Mr. Perry's plea.
Would the court excuse me to step out and contact Cherokee?
Yes.
To Jordan's office to kind of let him know.
Yep.
A little bit about what's going on.
Yep.
Because it was, like I said, it was really last minute, and then, so I just want to let them know, because that case is not sold at the trial, so I have a client waiting to possibly maybe they'll let us come in a different day this week to keep up. All right, I'm waiting for hours, so.
Sounds good.
Call them at the court.
Please do.
Thank you, Judge. And Ms. Smith, I'm gonna go one outside.
It'll be worth it to work that case out. Ooh, but that's what Emerson was supposed to do. All right, Rakestraw.
Thank you.
Ms. Shelton,
Yes.
are we going forward?
Your Honor, we are going to stipulate to the arrest, and
Okay.
then we will go non-negotiated on sentencing.
Okay.
It'll likely just be argument.
Okay. Can we excuse the officer then or around?
We can excuse the officer since it'll be a stipulation in this case.
There you go. Appreciate you being here. You helped force the issue. You were here ready to go and we're able to short circuit a little bit. So appreciate your time.
For sure. Thank you so much.
Let's bring Mr. Rakestraw out, please. Hey, Mr. Rakestraw, you can take a seat right there.
But not in the past. Since you've been, it's not over, okay? Absolutely.
All right, let's get on the record. This is 24 SC 005-735, State versus Rakestraw. Mr. Rakestraw is in court with his lawyer, Ms. Shelton. We have Ms. Smith here for the state. And Mr. Rakestraw, we are together because you are alleged to have violated the terms of your probation. You were on probation for a drug and firearm case that you were sentenced at the end of 2024. According to probation, you've got 3 years and 3 months left. 3 years, 3 months remaining on your probation. And the allegations are, one, in November of last year, you were arrested for burglary in the second degree and again having a weapon. And I guess this was in Sandy Springs. The officer was just here. And then also you hadn't done much of your community service. The community service wasn't the big deal, although you need to do it. It's getting arrested for burglary in the second degree. And I think we had a hearing where maybe you were going to resolve this, but the state's recommendation was significantly different. And so Ms. Shelton said, you know what, we're going to require the state to prove it up, which is, of course, the state's burden, never yours. But now it sounds like we're going to go through a stipulation on your side. I'm going to let Ms. Shelton speak for you, where you're going to acknowledge, hey, I got arrested for this stuff. Ms. Shelton will have a recommendation as to what should happen. Ms. Smith will. And then we also have Ms. Simpson from probation, who's on the Zoom call, and I'll be hearing from her. And when she's talking, you'll get to see her, and we'll figure out what we're going to do. Does that make sense?
Yes, sir.
Any questions about that process?
So, Your Honor.
Okay. Well, Ms. Shelton, I'll start with you. And as long as, if that microphone is on, if it's got a green light on it, you're welcome to stay there. Otherwise, I need you up at the podium.
Thank you, Your Honor. I first want to say that we do stipulate that there was an arrest, Your Honor, but we believe that the allegations are greatly different from what happened and what the state believes happened. We believe that our client had a right to be there and
Where is the there?
at the storage unit where he was arrested.
Okay, what kind of store was it?
A storage unit.
Oh, storage unit in Sandy Springs.
Yes.
All right, and you're saying if this had been more fully litigated, there would have been a defense of it was okay for me, meaning Mr. Rakestraw, to be there.
Yes.
Okay.
Yes, Your Honor. So we do stipulate that he was arrested. We believe that the allegations will show that that these charges will not hold up in court. Mr. Rakestraw is a 28-year-old man. He is currently in college. He is working on getting his I believe it's HVAC, right?
Yes.
His HVAC degree certification. He was supposed to graduate in February. They were holding out for him. Unfortunately, he was unable to be there. He has been incarcerated since about mid-November last year. He is going to get a job with that certificate, Your Honor. He has retained counsel for this. We are asking that the court give him time served as he has been in for 3 months and let him be released on the terms of his probation. As the court indicated, he needs to get some community service done and he would be able to do that once released.
Sure. So Ms. Shelton, you and your firm are not representing Mr. Rakestraw on the second-degree burglary.
We have not yet been hired for that.
Okay, but you mentioned that he's retained counsel. He's
For the-
clearly for this, because you have this, it's a limited entry for probation revocation only. But then I thought you said he has a lawyer for the new case as well, or he's working on getting a lawyer.
He is working on it.
Got it. Okay, which might be you.
It might be me.
Okay, all right. So your recommendation is effectively, I'm gonna call it 4 months. Mr. Rakestraw has served 115 days. And so I'd probably round it out at 4 months if I followed your recommendation.
Yes, Your Honor, that's our recommendation.
Okay. Anything else on behalf of Mr. Rakestraw?
No, he has had an issue. Well, I'll just say that both of his parents would like him home. He has the support of both of his parents. They were both at the first hearing. They want him home. They will ensure that he follows the terms of his probation to a T. They will ensure that he's going to school and doing his community service, Your Honor.
I have an address of Calumet Road. Is that where his parents live?
Yes, Your Honor.
Okay, and you'd be able to stay there, Mr. Rakestraw? Okay, got it. And where were you getting your HVAC certificate?
A UEI on Memorial Drive.
Okay. All right. Thank you.
Thank you.
Ms. Smith?
Yes, Your Honor, in this case, the state will be following the probation's recommendation to revoke 3 years and to terminate the balance, mostly because this offense happened just over a year after he pled guilty to the first firearm and drugs case. And in this case, the allegations again involve a firearm and also a serious crime of burglary. The state believes, contrary to defense, that there was a significant amount of evidence showing that the defendant was not supposed to be there and that when litigated, this case may resolve in a different way. Based on that, we're going to be asking to revoke the 3 years and to terminate the balance.
So I guess I need to hear a little bit about what you think the evidence would have been, and we're not going to fully litigate it, and I'll certainly give Ms. Shelton the chance to say, and it won't be her client's testimony, so she's not binding him to it, like, well, here's why it might be viewed differently. But to me, the firearm piece is concerning above all because Mr. Rakestraw is a felon and wasn't supposed to have it. And in fact, he had received conditional discharge in the plea that he took with Ms. Wood in November of 24. So it's sort of a first offender-ish sentence. And I'm not hearing you say you want to revoke that, but I'm confident we had a pretty healthy discussion about how you can't have a gun while you're serving out that sentence. And then a year later, this situation happened. So you had the officer here, he was going to testify. Just give me a synopsis of what you understand the situation to have been.
Got it. So on the day of the incident, the officer responding to a 911 call about a break-in. The manager of the public storage unit that was located at the incident location, she lives on site. And while she was sleeping, she heard banging, she heard commotion. She looked at the cameras and saw two people who were later identified as the defendant and the co-defendant with ski masks on, book bags, breaking into storage units. When the officer—
But it's plural, not singular. Units.
Yes.
Okay.
Well, that was the report. They were breaking into storage units. When the officers got there, the officer saw the defendant inside of storage unit 4119. The defendant told the officers that the storage unit belonged to his girlfriend, who was the co-defendant in this case.
Oh.
The officers then encountered the co-defendant, who said that the storage unit belonged to another person who was neither the defendant or the co-defendant in this case. The officers recovered once they searched, and after they arrested him, they searched him and found a weapon in his waistband. They also found his
Weapon as in gun or?
A gun.
Okay.
It was a Glock. They also found a book bag that belonged to him that had, I believe, like cutters, gloves, tools for the commission of a crime. There was also a book bag found that belonged to the co-defendant that had similar items in the book bag. At that time, the defendants were arrested. However, the state did reach out to the public storage facility, and we obtained a contract for the storage unit 4119 that the defendant was found inside of. And the person that's named on that contract is not the defendant's name, and is neither the co-defendant's name. So when I stated that the state has significant evidence to show that the defendant was not supposed to be there, that's the evidence that I'm referring to, that the storage unit did not belong to the defendant, it did not belong to the co-defendant. And based on the statements made to the officer by both the defendant and co-defendant in this case, it was clear that the storage unit did not belong to them.
Okay, got it. Thank you.
No problem.
So Ms. Shelton, I'm not asking you to reveal any defense. It does sound like a situation where your client may have believed that he or the person he was with had a connection to the storage unit. The paperwork's going to show what it shows. It sounds like it was not your client's name, or I don't know if girlfriend is the right title, but co-defendant's name. That doesn't mean they don't have a connection to the unit, but neither of their names was on the, I don't know if you lease them, the lease for the storage unit. So that's a little problematic, but it doesn't exclude your defense. Of course, I'm concerned about the gun, the firearm, and it sounds like it was sort of a furtive entry if people are wearing masks and they've got this equipment. But maybe it was sort of a repo operation, depending on what was in there and why they thought they should get at it. And you don't need to say anything at all, but I want to give you an opportunity to say, Judge, that's one way of looking at it, but here's another way of looking at what happened.
The only thing I would say, Judge, is I believe that the evidence would show that they did have a proper reason to be in the unit, regardless of it not being rented directly to them.
Got it.
The firearm piece, the firearm was registered to the co-defendant. My client, Mr. Rakestraw, put it in his waistband, and it wasn't, there was no allegation that he pulled it out, that he was attempting to use it to cause fear in any other person. I think it was more of you can put this in your waistband. Mr. Rakestraw has been shot before when he was younger. His father has been shot when he was younger. He does have a strong fear of being shot. I understand the possession of it does violate his probation terms, but again, I haven't heard or read any allegation that he was attempting to do anything with the firearm other than have it on himself for his own protection.
Got it. Okay. Ms. Smith, would the officer have testified to there being evidence of forced entry into 4119, or it was unlocked, or they had a key?
Yes, Your Honor. He would have testified that the storage unit lock was broken, and based on his investigation, he would have determined that it was forced entry based on the lock being broken. Understood.
Your recommendation, which you said is also probation's, was to revoke 3 years and then terminate. Mr. Rakestraw's sentence had 5 years consecutive to the probation suspended. It was just sort of close out the whole case, or I don't know how we process that suspended piece.
Yes, Your Honor. Based on the suspended piece, I would change my recommendation to reinstate the balance because I don't want to have to terminate 5 extra years.
Okay, got it. Okay.
And
Yes, ma'am. Ms. Shelton.
if I may, I believe that the evidence would show that my client was actually placing a lock on the unit and not, or maybe for fixing a lock that was broken on the unit, but they did not break it.
Okay. And I guess, Ms. Smith, there ultimately may be a co-defendant in, because this November 25 storage unit situation hasn't been accused or indicted yet. There still may be 2 defendants in that case. We're just talking about Mr. Rakestraw because the young lady either wasn't on probation or at least wasn't on probation in this courtroom.
That's correct.
Okay, got it. All right. Ms. Simpson, anything that you want to add from DCS's side?
Good morning, Judge. Yes, I just wanted to include that Mr. Rakestraw also has a probation warrant out of DeKalb County.
For this situation?
Yes, Judge.
Got it. So that will be his next destination. I guess maybe that's why he didn't get, what is he on probation for in DeKalb County?
It is for theft by receiving stolen property.
Okay. All right. Okay. Mr. Rakestraw, anything you want to add? You don't have to say anything at all, and your lawyer will be unhappy if you talk about the facts of your case, but I want to give you a chance if there's something you want to add.
You know, I really didn't break anything. I just beg. I mean, you know, I just pray that you all just give me a chance to show you. Feel me? I've been in school. I've been trying to do everything right. You know, I made a mistake. Yes, I know, but you know, I really just want to just do the right thing. You know, I just really want to take care of my family and everything I can. I just hope you all just show me mercy and give me that chance to do that and show you all that I'm gonna do the right thing.
Okay. Ms. Shelton, someone has come into court and raised her hand. I don't.
That's his mom.
That's his mom. Okay, got it. Thank you. Okay. Mr. Rakestraw, I'm guessing your sentence out of DeKalb County was a first offender because you didn't do first offender here. You were able to do conditional discharge, even though that was a little bit of a stretch. Ms. Wood can be persuasive and the prosecutor was amenable. And so you actually got 2 chances. Your DeKalb case is not a conviction. Your Fulton case is not a conviction. You've used up all.
I'm sorry, Judge. It's not.
It's not first offender.
No, Judge.
Oh, did he get first offender somewhere else?
Let's see. Not. It doesn't appear so, Judge.
Okay, well, be that as it may. Give me 1 second. This case is not a conviction, so that was a second chance of sorts. It not going to show up on your criminal history. The state is not asking to have the conditional discharge revoked, but I can understand why there is concern both from probation and from the district attorney's office that barely a year after we went through this situation, and you were sentenced for having a gun when you shouldn't, and having the drugs that you had, you got mixed up in this situation. And maybe it was bad choices. Maybe you had in your mind a good reason to be there. Still a little bit of a mystery, your connection and the young lady's connection to the unit. But that's not troubling me. I'm sure there's an explanation. And if these other charges go forward, Ms. Shelton's going to help explain that to the prosecutor and to a judge, and you'll work through that accordingly. But in the meantime, you knew that that was a risky thing to do. Ski mask, gun, middle of the night, whether you're breaking in or replacing a lock, a unit that's not yours, that's the last place you should have been. No matter how you may have felt about the young lady you were with, because you had a lot riding on keeping things clean while you were on this conditional discharge probation, which the state agreed to go along with. What I'm going to do, Mr. Rakestraw, in light of this situation, and again, to me, the most troubling part is that there was a gun in the mix, and I don't really care whose gun it is. It was in your waistband, and you need to be far from those things. I'm going to revoke a year of your probation. I will reinstate the balance. You are not getting credit for the time you served, because I was going to revoke about 18 months, but you've been in for 4. I'm just going to keep it a nice round number. So I'm revoking 1 year starting today. I will reinstate your probation. So you'll be back on probation. You're going to go to DeKalb County next. They have a hold on you because you're on probation there for the theft by receiving. They will look at this revocation and probably say, all right, that seems like a reasonable outcome. I don't control that, but there's often signaling between the counties. And then you'll be back on probation. When you are released, you got to report to probation within 48 hours, okay? Any questions about that? Ms. Smith, anything else from the state?
Nothing further, Your Honor, thank you.
Ms. Simpson, anything from the department?
Nothing, Judge.
Okay, that's it. Thank you, Ms. Shelton, for being here.
Thank you, Judge. Thank you for holding as well. That concludes my business, maybe.
Yes, ma'am. You can't, once Mr. Rakestraw steps out, I'm happy to hear from you.
I love you, Mom.
Ms. Smith, do you have time to chat with
Yes. Give me 1 second.
Ms. Glad? No, do what you need to do, but then, if Judge Emerson, well, I guess I'll take the plea.
I'm not sure if there would be a plea, Your Honor.
There may not be, but if you can, once you have wrapped up your 2 things, if you would chat with her, that would be great.
Yes, Your Honor. I'm gonna go back there and talk to him. Oh my, I'm going to kill myself. I can't say this anymore. I said, oh, baby.
Ms. Shelton, is there anything else?
No, Judge, I'm sorry.
No, you're welcome to stay. I just want to make sure if you needed anything else.
No, Judge, I don't.
Okay, all right. I need to do the Winslow final disposition, so you can take care of him.
I mean, okay, Judge, I'm sorry, Ms. Rayshaw does want to say something.
Yes, ma'am.
I watched him since the last time he was here. I literally watched him live feed. I know that you are a fair judge, and I thank you for not doing his hard. Christian doesn't know how to verbalize things. Christian's grandmother fell down and died. Like, he had to help pick up her body. She burst her head open and she fell down and she died. He has been my husband's, this is his grandmother, my husband's mother. He is taking care of her while we were in the hospital. It took almost a month to die. The day that he was arrested, he was trying to go to the storage unit to get stuff to go to his grandmother's funeral the next day, and I don't know if you've already involved this, but I just want you to know the boy, last day of school, he got out. You changed his life. You really changed his life within weeks of him getting out. He was enrolled in school. He had a job. He was super happy. He got around the wrong person and toward him. And I would have him, but he was honestly just trying to get ready for his grandmother's funeral. He's grieving. I don't know about the whole gun thing, but Christian was walking out of a Walmart shortly after he graduated from high school. And there is no backstory to it. You can look it up on the news. There was a random fight. There was a random fight in Walmart. He had nothing to do with it. And as he was fleeing to his car, he got shot in his back, suffered PTSD, doesn't take his medication. In the same house where my mother-in-law fell and cracked her head, a group of teenagers the year before followed my husband home from GameStop, and in front of my 11-year-old daughter, shot my husband 5 times in that same house. Christian came again and became a father to my 11-year-old. He is a good kid, good kid.
Well, he's got a lot of time ahead of him to continue to be a good kid, ma'am. I'm hearing you. He's got some things to work through. He's got to, whether it was the young lady or it was the grief over losing his grandmother, he can't be around the guns. And that situation of being there with the ski masks and whatnot, you can understand why the person who worked there got scared and called 911. And fortunately, no one got hurt, which is great. But he has a good future ahead of him, and can plug back in with HVAC. He just needs to stay out of those sketchy situations. And this was clearly one of those that.
Literally, he got certified the day before.
Yeah, well, he will remain certified and he's going to be good at what he does. He's going to take a little break to reflect on doing things differently, especially while he's on probation. And I had forgotten that he had the case out of DeKalb as well. So he has got to be extra boring and staying on the straight and narrow over the next couple years. And this will pass. And if he does well with probation, they'll get him on unsupervised, and there's still a behavioral incentive date, and then he can get to working. And that's what you want. That's what I want. But when there's something like this happens, it's a little too late to say, hey, second chance, because he was already working on his second chance. But he's been through a lot, and no one should have to see some of the things he's seen. Hopefully, with counseling and taking the right medication, and you can help him stay on that, he will process things better and not put himself in a situation like he was at the public storage place. We're all fortunate that no one got shot that night. Guns and dark nights and burglaries, and everyone gets a little twitchy. You have reason to be sad right now, but there's also some relief that this is as bad as it was. It wasn't worse than that.
I just as a mother, and then me and my firstborn, I was 15 years old when I had him, so I worked, I went to college, I became, you know, that first responder, and our whole family is first responders. He was gonna be a first responder until he got shot. It kind of messed him up.
Yeah.
You know, and I just, I just love him so much. I thank you for being.
Well, keep being there for him. Having family makes a big, big difference. I see young men who don't have that, and you are there for him, and make sure others are as well. Okay? Thank you for being here. Okay.
Thank you, Judge.
You're welcome. All right, so I did the final disposition. I'll send it to Ms. Nelson. You want me also print it, or do you need it to be filed first?
So just print it for me.
Okay, well, let me send it to her. So is he just sitting back there? The guy who you took into custody?
He's in cell.
Okay. Until you get the paperwork, he can't go downstairs. He's probably all right with that. All right, let me see if I can make
Might
it.
sleep,
Hmm?
sleep. Is that the guy that 53?
Yep, let's see if it'll print. Looks like it's going.
Yeah, Judge Ashley on trial as well too.
Judge Ashley?
Ashley.
Oh. Yep. He's moving Judge Barwick's cases.
Who would take over, Judge Williams? Nobody.
TBD. They're thinking about trying to get Judge Barwick to come back as a senior judge to do her stuff. And then Baxter could help with Williams. So Ms. Simpson, if you don't mind hanging in here, we're going to see if we are getting a plea with Mr. Perry.
Not a problem, Judge.
Thanks. Two copies. I'm gonna say hi to Monica. She was gone all last week.
I seen about the, when I went to go print the commitment for. He was on, spring break.
Yep.
Oh, they have so many spring breaks, man.
Okay, Judge, I'm sorry.
That's all right. Have you,
Leave.
did you connect with Ms. Smith?
No,
Oh.
I'll sit right there.
She's in the jury room.
Okay, thank you,
So you
Judge.
head back there.
Thank you. I was talking to Cherokee County and
Okay,
put that case off until tomorrow, so.
okay.
I worked, it was a race, not this past weekend, a weekend, 2 weekends ago. And the checkpoint I was at, it's at his address. Yeah, it's crazy.
Hmm.
By the zoo.
Pardon me?
It was by the zoo,
What address?
his address. So the checkpoint I was at when I was, doing traffic for the
Yeah,
race.
yeah, yeah.
It's by his address.
Oh, this guy?
Yeah,
He lives by the zoo?
yeah.
Huh, okay,
Armin.
okay. I didn't know, the school he worked at's up in North Fulton, but that don't mean he can't live down in Grant Park. Huh.
So that's Grant Park area.
The zoo is in Grant Park, yeah.
So. No, I'm feeling the one. Yeah, you know.
So did you know
Lynch?
Lynch?
Yes,
Yeah,
fun guy.
he seemed like a nice guy, but a traffic unit? Come on, you don't have people to do that?
We did have a traffic unit.
I understand, but how do you justify staffing a traffic unit when
This was when we was.
times were good?
Yeah,
Times were good. Yep.
He actually been in jail for a minute.
Yeah. So where would he be? So Lieutenant Petty, would he have, she's in juvenile now, I know, but I got to know her because of this thing we were doing with having non-complex do calendars out there. And she kind of seemed to be, I mean, she's not Clark, but she's kind of seemed to be in charge-ish.
I guess because she's under the umbrella of Colonel.
Okay, and he's not.
Yeah, he's not.
Who's he under?
He's under
Clark?
Butler.
Oh,
Lieutenant Colonel Butler.
does he do transport?
No, he's just the lieutenant colonel of the jail.
Oh,
He does transport too. He was one of the ones that had to go get checked in because of the fire with Pierce. When Pierce he was the one.
oh, the fire. Yeah. Oh, Lynch was? Oh my gosh. Huh.
So most of the time he's the one calling over the radio. They need to forward to the jail. He has
Okay.
to transport.
Got it.
And I guess he stops the checkpoints and the guard checks and stuff.
Yeah. Yeah, so Colonel Edwards said whoever was at juvenile left. Whatever with the LT would have been there.
She's in Bundy.
Oh, she got moved.
Yeah.
Okay, it wasn't that they stopped working at the sheriff's office. Okay.
It was a big movement last week.
Would that be viewed as a good move to go from jail to juvenile?
Yeah, some people are.
Okay. But it wasn't that now she's a sergeant or something. She's still a lieutenant and she's out of the jail. I didn't know that I guess it's big enough. There are enough courtrooms. Do you guys provide security in all the courtrooms at juvenile court?
Like maybe 8 deputies now.
Huh? Okay.
But most of the time, they're not even there. They're getting deployed to the jail or graded. So over here,
Pardon me?
I say most of the time they're not even that down there. You got graded with jail or here.
Yeah. Yeah. But it's good that you can flex that way so that if it's quiet there, they can bring people over here.
They say juvenile used to be done by like 2, 3 o'clock. They rarely go over
Yeah. Not like some of our 7 p.m.s.
8, 9 o'clock at night.
You see what we have tomorrow, if that's going to be inquiry, plea and arraignment, final plea. Yeah, it could be. We got drug court Wednesday. Oh, there is a hearing on Comer on Wednesday. So they just got the wrong day. I wonder what was filed. Let me look. Oh, it's to sever, because it's 2 murders. And Ms. Wood is saying they're not connected other than they're in the same indictment. So you got to try them on one murder.
They could combine over.
You can put anything you want in an indictment, and then a defense attorney can say, look, there was a burglary in May and a drug arrest in July. Those are unrelated. You can't try them together. And generally, the defense would be right if they are so disconnected. I don't know anything about Comer's case, but if I'm making it up, but if he stole a car and in trying to get away, he's shooting out the windows and shot someone and 10 minutes later shot someone else, those could be in the same indictment because it's one chain of events. But let's see what this says. Oh, wait, this isn't even the right. This was his other lawyer filed. She wanted to suppress a photo lineup. That's not a motion to sever. I thought Ms. Wood had filed something saying we need to do the murder separately, but the lawyer he had before said there was a bad photo lineup. Oh,
Judge Miss Wood filed one earlier than that one, when she was originally on the case.
Oh, she was on the case and then had to come off and is now back on?
I do believe so.
Huh. And are we on Wednesday doing that motion to separate the 2 murders, or are we doing the suppress ID, or both?
I thought it was to sever.
Okay. I guess we should shoot an email. I'll do that now so that people are prepared for the hearing, because they'll need an officer or a detective if it's to suppress the photo ID. But I'll send an email out. And I don't know what's happening with Mr. Perry. Ms. Smith is dealing with Ms. Gladden right now in the jury room.
Okay.
So I'm sitting tight. Ms. Hightower, her lawyer is on extended medical leave. But if he folds, I assume, yeah. There's a lot going on there.
My driver's license.
Judge, I have a question.
Yes, Ms. Simpson.
One of our drug court participants, Kelvin Washington, he had absconded back in 2022, brought him back, and he was given a second chance in the program. So we dismissed the warrant that was initially done because, different rule at that time. But I found out, it was brought to my attention that a tolling order was also done. Do I need to have the officer submit a dismissal for the tolling order?
I guess so, because if he's in drug court now, then he ought to be earning credit towards his probationary term. So if that clock is frozen because of the tolling order, we need to start it up again so that it is winding down.
Well, the funny thing is that's how I didn't realize they didn't toll it in our system. So that's how I wasn't aware of it. It wasn't until Officer Akuzu brought it to my attention that a tolling order was signed the same day as the warrant. So we had went ahead and dismissed the warrant, but I didn't realize there was a tolling order as well. So it wasn't processed in our system, but because it's a signed order, do I need to submit a dismissal for the tolling order?
Well, not if nothing was told, then it's like people ignored it. But was it told or not told?
It was not told because he wouldn't have an expiration date if it was.
Yeah.
And that part never changed.
Is his probation long enough that he will be able to get through drug court?
Let's see. Oh, my mistake. They did it after the fact. She did toll it, but she's put it in there after the fact. So now I'm gonna have to do a dismissal.
Okay, send it my way.
Thank you, Judge.
You bet.
And yes, to answer your initial question, yes, he does.
Okay, great. Are they doing things next door?
I gotta be very strong.
Oh. Do you need me to step off so you can get them downstairs?
Uh.
Okay. Okay.
I'm sorry, Your Honor, may I, we're in discussions, I'm going to go get some water to, I take an allergy medicine, and sometimes my mouth gets really dry, so I'm just gonna go there, we're talking there, she's having to make some calls.
Do you need to bring Mr. Perry up here?
I will also talk to him about that, but we have one sticking point, it's not the sentence, it's the charges, and we're.
Okay,
So, I think we're really close.
okay.
Thank you, Joe.
Hey, you got room for one of them? No, that's a sentencing. Yeah, he turned himself in. Uh,
So what do you have to do during the World Cup? Have they begun to talk about that? You're gonna be working 24-hour shifts?
I wouldn't say 24 hours, but they got those data, we can't take off, we can't do nothing. So,
We will be open for some of them. I think that final game, which is like a semifinal or something, where they're actually shutting down North Side.
oh, wow.
Well, we couldn't have court, could we? Because how are you gonna get inmates here if you can't get across North Side? So I think that day may be there's nothing going on here, but for the others, the discussion was more, hey, try not to have jurors that day or something.
How many games is it total?
I think it's, oh, I'm gonna get it wrong, 8-6. But you know, some of them are early on, and while it's World Cup and that's exciting, it's not the same as the semifinal where all the pressure has built up. So it'll be zany near Mercedes-Benz, and then I guess they do something at Centennial Park. But I think we should be all right.
From like June, can't do nothing.
But only on the days of the games or even in between?
In between,
Wow.
so you know, tell them what they gonna have us doing.
Yeah.
That kind of slight idea.
All right, I'm gonna go back. I'll mute this and just let me know.
Take him down then.
Okay. I'm back in court with an update on taking a plea with Mr. Perry. We're gonna do that at 1:30 today, so folks don't need to stay. I'll leave the Zoom up and running, but if you want to sign off, as long as you're back on at 1:28, we'll try to get going at 1:30. Does that work for you, Ms. Rivers?
Yes, I'm fine. I'm right here.
Great. So I'll just put this on mute, and we'll get back on at 1:30. It should be interesting, so bring your typing fingers. Ms. Simpson, are you able to rejoin us at 1:30?
Yes, Judge, this was all I had for today.
Okay, we'll have a long lunch break. Mr. York, can you be back at 1:30?
Yes, sir. And what's Mr. Perry's first name?
I think it's Mantrell, but I'll give you the indictment number.
Okay.
It is, hold on a second. 24 SC 002 244. And they're co-defendants. We're dealing with Mr. Perry. And again, I think his first name is Mantrell.
Okay, thank you.
You bet. I'll see everyone at 1:30. Thanks for your flexibility.
Judge,
Ms. Nelson.
do you want me to just extend this Zoom? Because it only goes till noon.
Sure, that'd be great. If you would do that.
Okay.
Please.
All right. Thanks.
Thanks.
Yeah, I think we, what did I do? I'm just letting this lady know.
Okay.
I'm negotiating the last week.
Okay, hold on one sec. I just worked with the staff. We've got different things. We're gonna do it, assuming everything is worked out at 1:30.
Okay.
Right here.
Tell them and then we'll.
They know, but you can tell them. But that way you guys can get a lunch break.
Then when I do the deal.
Yep,
Okay.
great. And then we just need everyone back here a little before 1:30 and we'll knock it out. We'll have the court reporter and everything, okay?
Just really quickly. Some judges have paperwork that needs to be filled out regarding the rights and stuff, working rights. And some judges just do it on the record. Does Your Honor have a rights sheet that we should be filling
I
out?
think it is
Oh, I should have looked.
the pile right there.
That's right
Yep, if you guys would have that filled out, please,
That's what I-
by 1:30. That's the only form you need to worry about.
It's a probation?
Nope. We'll have Ms. Simpson on the call and she'll manage that.
And they're all being, it's all misdemeanors too. I don't know if that's gonna be felony or misdemeanor.
That'll be misdemeanor probation, but we'll manage that one as well.
Yes, Judge.
Okay.
And I'm just gonna let them know that it's a done deal so they can, look at that.
All right, 1:30.
Thank you, Judge.
I mean, stay in touch with her, but 1:30.
Excuse me, Judge. Oh, you were talking.
I was just telling Mr. Perry that he needs to be back here.
Stay outside away from me and then yeah.
Just wait right there. She'll come back through. That way, I don't want you guys getting disconnected. There we go. And we've got Ms. Rivers. Hey, Ms. Rivers, good afternoon.
Good afternoon, Judge.
You ready to go?
Yes, I am.
Yes, sir.
Great.
She's the court for us.
Okay, let's get on the record. This is State versus Perry. Mr. Perry is here in court with his attorney, Ms. Gladden. It's indictment 24 SC 002244. Ms. Smith is here for the state. And let me adjust one more thing here. There we go. It sounds like, Mr. Perry, you are ready to enter at long last a plea in your case. Is that correct?
Yes, sir.
Okay. The way this will work is that in just a moment, Ms. Smith will put you under oath. She will ask you questions about your case, about your rights. You need to answer those truthfully and completely. If at any point during the conversation you have questions, someone says something that doesn't make sense or it's not going the way you and Ms. Gladden thought it was going to be going, I need you to tell me so we can try to answer your question. Will you do that?
Yes, sir.
Okay.
And make sure you're loud enough.
Yeah, and make
So
sure
the
you.
court reporter can take down your.
Exactly. Just make sure you speak loudly when you are answering questions so that Ms. Rivers, the court reporter, can hear you. And with that, Ms. Smith, when you're
To
ready.
be loud.
Left ear field, they should speak.
Hmm?
My left ear field, left ear.
Okay. And Your Honor, his left ear is deaf, so he's trying to make sure that he's hearing.
That's fine. If you need to turn a little bit, you can turn a little bit.
Yeah, my left ear deaf.
That's fine. Whichever way you need to turn.
All right. Mr. Perry, please raise your right hand.
Raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
My witness.
Your true, correct, and legal name for the court.
Mantrail, D-Line Pair.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
47 did to 12th grade.
He got his GED, Judge. Thank you.
I didn't,
Huh? Yeah.
ma'am.
11th grade with a GED.
You got your GED?
Yes, sir. I got it when I was in prison.
Okay.
Really quick, Your Honor. This is gonna be a misdemeanor plea. I did not tell you at the beginning. Would you like me to tell you about those reductions now?
No, you'll get to it when you get there, but someone had forecast that it was a misdemeanor plea. I knew that coming in.
Got you. Mr. Perry, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I do.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Perry, do you remember being arrested on these charges?
Do you remember being arrested on these charges?
Yes, I was incarcerated.
Do you?
But at some point you did get
Got
arrested in
arrested in the
connection.
Oh,
first,
yes.
yes.
Okay.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, to our knowledge, there are no outstanding warrants related to these charges.
Mr. Perry, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 84 months for 24 months to be served and the rest to be served on probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
If you're currently on probation, do you understand that your probation may be revoked based on you entering this guilty plea today?
And this arrest occurred before his probation, or they already know about it, Judge, we've already gone through that, but technically, legally, it could, invoke a probation revocation.
Yes, ma'am.
Mr. Perry, are you on probation here in Fulton or in another county?
Fulton.
Fulton? Okay.
I think this occurred before.
He was sentenced in the other case? Okay.
Mr. Perry, are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Perry, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 24 SC 002244, how do you plead to count one, a reduced charge of criminal trespass?
To the reduced charge of criminal trespass, how do you plead? Guilty.
Yes, ma'am.
You plead guilty?
Guilty.
Okay, you have to say the word, thank you.
Okay. How do you plead to charges 2 through 5, a reduced charge of reckless conduct?
Guilty.
How do you plead to count 6, a reduced charge of pointing or waving a firearm at someone?
Judge, guilty, thank you.
Well, he needs to say it.
Judge, I was just gonna add to it.
Okay, you'll get the chance to
Thank you, Judge.
layer all that on there.
I need to re-say it.
Just ask again, but before you do, so Mr. Perry's not charged in count 2. So he's entered a plea to count 1, criminal trespass. And then he's entering a guilty plea to 3 through 5, you were saying, or 3 through 6? I'm just looking at the counts he's charged with.
The
3 through 6, those are all aggravated assaults. Are those the reckless conducts?
Yes, Your Honor.
All right, so that's counts 3 through 6. The next count is count 11, which was possession of a firearm during commission of a felony. That's being reduced to?
Pointing or waving a firearm.
Okay, and that's a misdemeanor. That's count 11. Are you pleading guilty to that?
Yes.
Okay, and then count 13 is cruelty to children in a third degree, which I think is a misdemeanor.
Yes, Your Honor.
Okay, are you pleading guilty to that?
Yes, sir.
And then finally, count 15 was possession of a firearm by a convicted felon. What is that being reduced to something, or is that being null pros?
That's been null pros.
Okay, got it. We covered all that. Thank you.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal to your guilty plea, but if you believe that there is some type of error in your guilty plea, that you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that process needs to happen within 30 days from today?
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Perry. Your Honor, if this case were to go to trial, the states would show that on October 29th, 2022, Officer Morgan with the Atlanta Police Department reported to 2207 NEMS Drive, that's NELMS Drive, regarding gunshots fired. The 911 call stated that a black male was shooting at him and his family Officer Morgan spoke with Devontae Lee, who is the victim in this case, who resided at 2207 Nims Road Southwest. Lee told the victim in this case, Mr. Lee told Officer Morgan that there was a dispute with his landlord, who was identified as the defendant in this case, Mr. Perry. The victim, Mr. Lee, stated that Hightower, who's the co-defendant in this case, drove her boyfriend, Mr. Perry, to this location to evict him and his family. And while he was there, they started to have an argument by the front door. Mr. Lee then reported that the defendant shot toward the door twice before coming into the residence with his firearm. At this time, the victim number 2, Ms. Maya Robinson, called 911 to report that the defendant was inside of the home and that he had a firearm. At this time, the co-defendant, Ms. Hightower, took and transported Mr. Perry from the incident location and took him back to his car. At the time the officers got there, the defendant was not on the scene. However, the officers did take Ms. Hightower, the co-defendant in this case, into custody, where she was taken to the jail and charged accordingly. Regarding the defendant in this case, they did take out warrants, performed a photo lineup, and once identified as Mr. Perry, the defendant in this case, as I stated, they took out warrants, and he was later arrested for the charges that was on the original indictment. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, we've agreed to a total amount of 84 months of, let me see how I want to say this. So it's 84 months total with 24 months to serve. However, this will be a backlog offer. So in this case, the first 5 years of probation, he would have to serve. However, if he does not complete the special conditions of probation, the defendant is to go into custody for 2 years. Regarding those special conditions of the suspended sentence, those conditions are for the defendant to complete 200 community service hours, for him to complete an anger management course, also for him to have no contact with the victims at all. That's Maya Robinson, Devontae Lee, and also Devontae Lee Jr. For the defendant to also complete a firearms safety course. And
Can't have a gun. He's a felon,
I
so
said that to you, Your Honor.
I'm gonna, well, keep going. I don't mean to interrupt.
okay. We did speak with defense about this. We were trying to find a program, and hopefully probation can find him a program of this. We want him to take a course where he understands the importance of not having a firearm if you're not supposed to have one. And if you are to have one, in what ways are you supposed to use it?
Okay.
I'm not sure how probation can.
I don't think they can authorize that because he can't have a firearm, but
Okay.
we have ways of creating an aversion to firearms with probation revocations. So, okay.
And also, Your Honor, of course, no weapons or guns in this case. But that is the negotiated offer between the state and the defense.
So you said suspended. I don't think you meant it's 5 years of misdemeanor probation.
That's correct.
Okay, followed by 2 years to serve, but those 2 years would become suspended and not to serve if probation goes smoothly.
That's
So it's the backloaded. Okay, got it.
Also, Your Honor, I just want to add really quick, I did have a chance to speak with the victim in this case, Mr. Lee. He is aware of the offer.
Okay.
We informed him of the reductions also.
Do you know, was it Ms. Hightower or Mr. Perry who was the landlord of this property on Nelms Drive?
Based on my understanding of the case, it was Mr. Perry who was the landlord.
Okay, so Hightower just drove him over there because he needed a ride, or?
That's my understanding, yes.
Okay, all right. And Mr. Lee understands what's happening. Mr. Lee Jr. was his son. Ms. Robinson was his girlfriend, roommate at the time?
That's correct.
Okay. And did you talk with Mr. Lee at all about whether, in fact, the eviction was appropriate? Not meaning how it was carried out, but yeah, I hadn't been paying rent for a while, or I had overstayed the lease, or what was his angle on that?
According to Mr. Lee, he said that he was there lawfully, that he had paid up on the rent. So there's
A dispute.
yeah.
Got it. Okay. All right. Thank you so much. Let me turn to first Ms. Simpson. Ms. Simpson, Mr. Perry said he is on probation. Is that Fulton or DeKalb? What do you have in your system?
That is Fulton, Judge. He is currently under docket 22 SC 184916. And he
Okay.
has 7 years and 7 months remaining on that case.
Is that the cocaine trafficking case?
Yes, Judge.
All right. And did that plea or sentencing happen after this incident happened? I can look it up. I just wasn't sure.
This plea does not, I know it won't put him in violation.
Okay, got it. So I think the cocaine trafficking may be older than this incident, but.
Yes, that's correct, Judge.
But the plea occurred.
In 23.
Got it. Okay. So no probation ramifications yet for you. And then I'd like to ask Mr. York if he could share with me criminal history on Mr. Perry.
Yes, sir. I'm showing 19 cycles with 7 felony convictions. The most recent I have is a 2020 was APD, possession of a Schedule 1 or 2 controlled substance. Then I have a 2017 Fulton County Sheriff, trafficking of controlled substances, possession of firearm or knife during commission of or attempt to commit certain felonies, theft by receiving stolen property, next there is a 2010 APD. So possession of cocaine with intent to distribute. Willful obstruction of law enforcement officers by use of threats or violence. The next one is also a 2010 APD. Possession of cocaine with intent to distribute. I have a 2009 APD, trafficking of controlled substances. I think it's 2 counts of that. I have a 2001 APD, aggravated assault and possession of cocaine with intent to distribute.
All right, that's far enough back. I appreciate it.
Yes, sir.
Thank you, sir. Thank you for joining us. All right, Ms. Gladden.
Yes. Thank you, Your Honor. I am not sure in how much detail I need to go to convince Your Honor that this is the correct plea, the correct sentencing in this case, which of course is what you are in control of and will be deciding here today. My client, of course, he and his wife, that is the co-defendant is his wife, they have 2 rooming houses. The rooming house, is the court familiar with how rooming houses work versus the regular tenant, a regular month-to-month or regular 12-month tenancy is concerned?
Yes.
Okay, so the way, as the court knows, after 1 week, if they haven't paid, they pay in advance. If they're there longer than a week and they haven't paid, they're subject to eviction. My client, at the time this occurred, and since then, of course, even longer, had had these residences for over 2 years at least, possibly 3. Had people coming in and out on a regular basis, had evicted numerous people because a lot of times people will come in and stay for a week. It's unfortunate that people have to be evicted, but these are the only circumstances which people can actually have a place to stay. A lot of people that are in this situation. So He has, again, evicted numerous people by that time. No one had ever filed a complaint against him, accused him of anything, even physical violence, because he is a big guy, much less it involving a weapon. Our side, what we would have argued at trial, Judge, is that they were already 2 weeks, and we would have receipts and things, they were already 2 weeks behind. Because there was a young child, a young man, a young boy, 8 years old, they had, they were trying to give them some leeway, but they had been telling them, since they had not prepaid each week for 2 weeks, that they had to leave. And they could have, after that first week, like I said, evicted them, but they were having, they just didn't want to barge in with a young boy. So, in fact, how they came to his rooming house in the first place was that they were being evicted from another rooming house. What people will do was, if they paid up the weeks they were behind at the first rooming house, they would still be evicted. They could take that same money, if they had $600, put it down to a new rooming house, and so they'd have 2 more weeks out of a month. 2 weeks basically worth of money for a whole 4 weeks worth of space. So they had paid 2 weeks in advance from after he picked them up and brought them to his place, moved in. They stayed there 2 weeks that they paid for. They had not paid now for 2 weeks, a week and a half, almost 2. I think it was after 2 weeks when this happened. They had talked to them several times. His wife, my client, had said, "You've got to leave. We've given you extra time, but you've got to leave." After this occurred, in fact, a friend of Mr. Perry's actually moved them to a different rooming house, so they were able to kind of do the same situation. That's why, again, we would argue, we would have people to say this is what they'd done before. So, bottom line, on this day in question, what my client, our position would be, they had the bottom part of the rooming house. There was an entrance directly into, which is on the side, on the left side, Judge. If you're facing it, it'll be on the left side. Their own entrance and a burglary door there. There was also an entrance with a burglary door, one flight up the stairs, which the other people used, but it wasn't locked off. It was just, the kitchen was kind of in the middle, and there were some apartments upstairs in that same floor, some bedrooms, and then they had the downstairs. They wouldn't get out. Our version would be, he went when all this happened to change the lock on the burglary door, not the lock on their door, but to change the lock on the burglary door. So, to kind of give them a warning, and they would know if when they left, they might have to get out the front. They just was trying to keep things actually from getting to this point. Again, they've had experience with the different things they've had to do without escalating. And he was in the process of drilling and he had his drill, of drilling the burglary door. You can't look out the window. They heard him, they opened the door, started arguing, and it progressed inside, but he did not have a weapon. He was changing the door. Now, what they actually told the police on the videos, and I've watched these body cams numerous times, Judge, is a little different. They said, and this is on the 911 text, Judge, which I have personally transcribed word for word, and then also what they told. I'm doing all this by myself to make sure I understood everything. They told so apparently they said that they heard a shot outside of their door, right outside the door. And that for some reason, not knowing who it was at the time, they couldn't see that it was Mr. Perry. They don't have a window or anything there to look out. They just, we heard a shotgun outside, 2 shots. Let's just open the door and see who it is, which is exactly what happened. It wasn't a forced entry, but the shotgun shell casings were on the outside. They were delicately placed, about 5 inches from the door. When the officers arrived, I guess it was about 30 minutes when they got there. And they weren't, what they said on the videos and in the 911 text, they heard the shot. They opened the door and they saw that it was my client. So here we have people hearing shots and all of a sudden, oh, let's just open the door and see who it is. And that he came in with a gun. They just let him in, I guess after they opened the door and saw who it was. And so here we have a gentleman who supposedly has, and when the cops asked them both about the gun, all they could say that it was a long gun. When I think of a long gun, I think of a rifle, but that's all the description. Even the officer tried to say, well, was it black? Yeah, but that's all either one of them could say. So if I don't know, but if I'm someone and I'm pulling a gun, I am not gonna, she made 3 911 calls right there. I'm not gonna let someone sit there and make 911 calls while I'm holding a gun on him, which is exactly what it was. He's right, he's pointing a gun at me, he's pointing a gun at my son. And I'm like, I'm not gonna let somebody make one, much less all these 911 calls without pointing a gun at. Judge, if I heard shots outside my door, I'm not going to open. See, I'm running out the front door with my child. I'm getting away. I don't know who it is, but I'm not going to find out. I'm going to go upstairs out a different entrance and run for the neighbors. It could have been a gang. It could have been, I don't know, but I don't open the door and I do try to escape, especially with a child. So,
Okay.
That's the point. So the police come, and the issue, a few other issues. The officer, when the one officer who there's also an issue with in a minute, instead of trying to do something with the shotgun shell, they don't even know what kind of gun it is to even see, of course not fingerprints, just to see what kind of gun it was. He just picks it up, puts it in his pocket.
Hello?
Gets sent off. Forensics don't get it.
Stop.
I'm sorry.
Yes?
Please stay by the microphone.
Oh, I'm sorry. Okay. I apologize, Judge. I'm used to. So there was no way of even knowing what gun it was supposed to be. So then later on, I'm going to skip forward. This same officer, okay, there were 3 officers, and I have the same on the tip of my tongue, that were talking to the victims.
Stay close to the podium.
Okay, that were talking to the victims mostly, Your Honor. And so they said, why don't you go canvass, see what happened. These houses are close together. They're smaller houses. I'm sure you've seen the neighborhood. So the same officer goes directly across the street. This is a woman, elderly woman who's lived in the neighborhood. To me, she even called herself the neighborhood gossip. She walks around all day and talks to people. So, ma'am, have you been here? How long have you been here? I've been here all day. Well, have you been in it? Yeah, I've been in and out of the house, walking up and down the street. He said, did you hear a gunshot or gunshots across the street within the last 20 or 30 minutes? She's like, no, absolutely not. I didn't hear any gunshots. He said, thank you, ma'am. Doesn't take her name, doesn't take her statement, keeps on going. There were 3 different houses he visits, Judge, where 4 different people say they did not hear gunshots. One guy had been out in his yard almost directly across the street, detailing his car for 3 hours. When he gets to the 5th person, but the 4th house, it was an elderly gentleman. All of a sudden, and I'm not saying this to deliberate, Judge, but had he even written any of this in, people might have investigated it more. But you could hear everything that happened between all the parties, both before, on his audio cam, before this incident. The one person who supposedly said he heard a gunshot, he walks up to the gentleman, he's within a few feet of him, and he said, what's your name, Mr. So-and-so? I said, have you been here all day or for a while? Yes, I've been right here at my garage working on my car. He said, did you hear any shots about 30 or 45 minutes ago? Suddenly, you can't hear, and the rest of the tape, you cannot hear anything this gentleman supposedly says, okay? The officer, but not him. And then the officer goes, oh, so you did hear a shot? You did hear shots? And the guy's saying something, but he's kind of shaking his head. He said, oh, so you were here and you did, like he's testifying about what this gentleman is supposed to be saying when he didn't even, like he asked the other people's questions. And this time it's like, oh, you have been here. Oh, you did hear a shot. Well, you can tell by his mouth that he's saying a lot more than that. but you can't hear it. I put it on audio. Now, the state may have a different tape, but I put it on the best headphones at the highest volume, and I can't hear anything. So, okay, so that would have been an issue. And then but he doesn't take the names of the 4 people who said they didn't hear anything. We don't actually hear what the person who said actually did say. And so he goes back and he tells us, oh yeah, I found somebody. If the investigators in the DA's office had even known, had he taken the names of these people who said they didn't hear anything, who knows what would have happened. It's not the DA's office, but when you're investigating a case, Judge, it's important to, if you talk to somebody and they say no, that, it's important to fill out all of the facts. And those are like the main things. We would have all these people from the neighborhood that we're talking about that they didn't know about would have come, and we did inform the DA's office. Lastly, and this is kind of a side note, the victim had called my client in the last 6 months or so, asking him for money in exchange for not showing up in court. Now, we have that on audio tape. That really is not relevant to the facts of the case, but it's just been one thing after another, Judge. And so that's why we feel, and that's why we were so adamant about trial, because my client, he's pled guilty to a lot of things, Judge. He's done a lot of things.
But not this.
But not this.
Okay.
And he had plenty of chance. So anyway, Judge, that is my presentation, why I ask you to accept the state's which of course that is their decision, but the state's recommended sentence. Thank you.
Okay, you're welcome. Mr. Perry, anything you want to add?
Just basically, you learn from your mistakes on how you go through life, and I've been going through a lot with my property. I own 3 houses. I've been going through a lot.
You're still in the rooming house business?
Yes, sir. I own them. I never lose those houses, but they've been passed down through to my grandparents. All 3 of them. I never lose them. I have them till the day I die. But yes, I've been like true experience with those houses, well, renting people rooms and evicting. So I had to learn myself exactly how to go by and study the law on rooming houses myself.
Okay, and you're still doing I know you still own the property. Are you also still renting them out?
Yes, sir. I'm still renting rooms right now.
Okay.
All 3, I'm still renting rooms right now today.
Do you have any questions about anything we've discussed?
No, sir.
Okay. Well, Mr. Perry, I find there's a factual basis for your plea to these misdemeanors, and the state has exclusive authority to reduce charges. I can't do that. They have. I also find that your plea is knowing and voluntary. Voluntary meaning no one's forcing you to enter the plea. And after you've had plenty of time to think about it, talk about it with Ms. Gladden, who's represented you very vigorously, you've decided that it's in your best interest to plead. Is that correct?
Yes, sir.
Okay. I have in my hands the plea of guilty form that has your initials next to all your rights that you're waiving and all that we've been talking about. Did you and Ms. Gladden have a chance to talk about this form?
Went over.
And then your signature is on page 4 of the form.
Yes, sir.
And Ms. Gladden, you signed it as well.
Yes, Your Honor.
Great, I'll make it part of the record. Ms. Smith, can someone in my office sign the indictment for you? Yes, sir. Ms. Gladden, can we sign for you?
Yes, Your Honor.
And Mr. Perry, is it okay if we electronically sign your name to the indictment to all these misdemeanors in one null pros?
Yes.
Yes, sir.
Okay. I'm going to follow the joint recommendation. Ms. Smith and her predecessors have been working on this case a whole lot more than I have, as they've been working with your lawyer. So what I'm going to do on count 1, which is criminal trespass, is sentence you to 12 months to serve 3 months with the balance on probation, but you'll get credit for the time you've already served.
Yes.
Count 3, which is reduced to reckless conduct, will be 12 months consecutive to count 1. Count 4 will be 12 months consecutive to count 3. Count 5 will be 12 months consecutive to count 4. And count 6 will be 12 months consecutive to count 5. That's a total of 60 months to serve 3 months, the rest on misdemeanor probation. Count 11 is going to be 12 months to serve, but that's at the back end, consecutive to those first 60 months. And then that's reduced to pointing a pistol. Counts 3 through 6 are reduced to reckless conduct. Count 11 is reduced to pointing a pistol. And count 13 was already a misdemeanor, so it stays as it is, and that's 12 months to serve consecutive to count 11. And finally, count 15, the state is dismissing. So the total sentence is 7 years. First 3 months to serve, but credit for the time you served. The next 57 months are on misdemeanor probation. And those final 24 months are actually time in custody. But if you successfully complete probation, I will convert those into suspended. So you're not even on probation for those. Special conditions of probation. Number one, most important one, no contact with Mr. Lee and his family. If he tries calling you, hitting you up for money or this or that, you just got to ignore it. Don't reach out to him. If he brings to the prosecutor text messages from you that are current, that's going to be a problem. All right?
Yes, sir.
If he says, hey, could I get another room? You can't do business with him. He has to find somewhere else. Number two, you're going to take an anger management course. And number three, 200 hours of community service, and you have to complete those in the first 12 months of your probation. This isn't something to string out to year 3 or year 4. I'm not going to be interested in considering an early termination to your probation or suspending those final 24 months if you haven't knocked out that community service, okay? And community service does not have to be picking up trash on the side of the road.
They got it different now.
Yeah, if you work with misdemeanor probation, as long as you find out in advance, hey, if I am at this youth center, or if I'm working at this soup kitchen or this clothes closet, and you can document it, you can't work at Hightower Enterprises or something that your wife runs. But if it's a legit nonprofit and they document the hours, that's where you can spend your time, okay?
Yes, sir.
I think I covered everything. I'm not going to do the firearm safety thing. No guns. If you are caught with a gun, you're going to come back to see me, and I'll revoke as much probation as I can. So stay away from the firearms.
Yes, sir.
Anything else, Ms. Smith, from the state?
Nothing further, thank you.
Ms. Gladden, anything else on behalf of Mr. Perry?
No, Your Honor, just I wanted to say thank you.
Sure.
And thank you to Ms. Smith as well.
Mr. Perry, you are going to be contacted by email or cell phone by misdemeanor probation. Don't ignore them. They may make you, oh, there's a piece of paper. I didn't know we had that for misdemeanor probation. Huh, new and improved. So if you haven't heard from them, you need to reach out to them so that you can get plugged in with their system.
Now, is he gonna fill this out and leave it with the court, or is he gonna take it, or what? I'm not sure.
It's a good question. Ms. Nelson, should Ms.
He
Yes.
would need to complete that form and send a picture of it to the email that's on that form.
Is there an email on that form?
Yes, there is.
So once you filled it out, take a picture of it and send it to that email address. That's how you register, and then they'll know how to reach you.
But we're not supposed to present it and it goes to the court.
No, ma'am.
Teacher.
Nope. So I'm giving you the key to start your misdemeanor probation.
Okay, I need to fill this out
Yep.
and take it to the probation place.
No, send it, take a picture of it or scan it or whatever and send it to either one of these. In fact, I would send it to both.
Okay.
And do that today.
And do it today.
In fact, you may want to sit with Ms. Gladden and fill it out here. But
I'm gonna do it right
at some
now.
point today, fill that out, take a picture of it, and send that to both those email addresses.
You know how
And
to
then-
forward an email? I mean, forward a picture to an email? You know how to do that?
I don't know how to write the emails like that.
Judge, I will wait for him to do it because
Okay.
I know how.
If you'll help them out, that would be great. If you're running into issues about how to connect with them, let Ms. Gladden know. If she needs help, she'll reach out to my staff.
Yes, sir.
But you need to plug in with probation,
Yes, ma'am.
okay?
Yes, sir.
Judge, will you please have them copy me on that email, please?
Yes, so let's add Ms. Nelson to that email.
Can I ask what her email address is?
Yeah, I'll get that to you in a minute.
Okay, thank you, Judge.
All right, before we do that, based on this plea going through, do you have any announcements, Ms. Smith, as to Ms. Hightower's case?
Yes, Your Honor, regarding Ms. Hightower, the state will be dismissing the charges.
Okay, we'll take care of that. We'll stamp the indictment, and that'll close out this case. Mr. Perry, you still have another case. Ms. Taylor is your lawyer on that case. We just resolved, this is the more serious set of charges, but we'll see each other again when Ms. Taylor is back, and she's out for another 11 days at least. But when she's done with her medical leave, we still need to sort out your other case.
Yes, sir.
It's not with Ms. Gladden, it's with Ms. Taylor. You understand?
Yes, sir.
Yes? Okay. All right, I think that's it. Thank you, everyone.
Thank you, Judge.
Thank you, Judge.
You're
and I will
welcome.
just sit here for the email address.
Yep.
And thank you, Judge.
Judge, he does understand that he will be supervised by 2 officers.
Yeah, so Mr. Perry, you're gonna have 2 different probation officers. You've got your felony probation in your cocaine case, and that's going on still. Misdemeanor probation is a different company, and so it's gonna be a different officer. Okay?
Yes, sir.
All right,
Thank you, Judge.
you bet. See you guys.
Your Honor, I'm going to go outside the courtroom and finish filling this out with Mr. Perry